Oh, no, 2 o'clock. All right. Everyone looks so happy to be here on Monday afternoon. Also noticed that people seem to sort of there's more of you getting more and more towards the front. Is that because I talk too quietly? Or is it you guys want to engage with the material and have in-depth conversations about things? Probably not. Okay, let's... Right, we're all good to go. Again, just note that this is streamed. I haven't had anybody jump up and tell me to not do this. So if you don't want me to stream it, send me an email and I won't. But it also means that you can get the recordings like straight away. I believe at the end of each particular recording when it finalizes it, you can just grab them. And if you can't, if you want an offline version, I think you can use things like clipconverter.cc. That'll just go and grab the thing and save it. If you guys really, really want to, I can go and take like an MP4 and save it on LangJCU, but I think it's going to be a moot point. All right. Secondly, is anybody wanting to do the presentations today? I've had not that many emails about doing that. And look, to be honest, I think that's probably quite wise. The first week's always going to be difficult. For those that aren't aware, we've had a room change for the tutes. So it's now room 105, just on the other side of the hall. A little tongue-in-cheek, I'd asked to move the 5 p.m. tute to just before the lecture at 1 p.m. Because there were 50 people enrolled in the one just after the lecture. And I even checked the room was free. Room 5 in the building 27. What they've actually given us is a larger room. So the tute hasn't been moved. I'm still going to try and move it for the half dozen people that are coming at 5 p.m. or whatever it is. No, I'm going to go, no, don't move it. Probably not going to get a third tute. That's the other thing as well. Sorry about that. All right. Now, does anybody have any questions from... Oh. I have a question? Oh, yeah, it's all good. Does anybody have, before we start, any particular questions, particularly involving admin issues that you want me to go over before we start the substantive material for today? Yeah. Yeah, so there's the one at 4, which is straight after the lecture. It's just over the hallway in room 105 in this building, which is actually a little bit convenient to do that. But it's not, to be honest, in terms of a learning experience, it's not going to be much different from a lecture, because there'll be 50 people. I mean, 80% of this room is going to be going across there. So, I mean, it's up to you guys. If you do want to go to the smaller class, if you've got the time, come back for the one after that at 5 p.m. And like I said, I'm still going to try and move the other one. Okay, judicial review. Now, you may have had a look at the subject outline and seen that judicial review is huge. We're going to be doing this for 9 weeks. So just make note that we'll, starting with all of the high-level bits and pieces to do with JR and going through both the, largely the statutory framework, but also some of the common law and constitutional rules as well. Things that you guys, and I believe most of you are probably enrolled in constitutional law now. If you're not, you may have done it last year or you'll do it next year. But there's a few constitutional issues that I'll talk about today, but largely I'm going to hand those off to Salome because it's probably more appropriate to go over it in that subject where you're really grounded in the constitutional stuff. Okay. Now, the slides, I have gone and basically I've got Jamie's material and it's very much based on that. So you'll find that there's a couple of changes, largely to do with a little bit of terminology. Something that comes out for some of the books and not others, and for Jamie's material as well. They use the term reviewability. I don't really like that term. I think it's not helpful. I think it's almost more useful to think of the aspects of judicial review that we're going to go over as essentially as 5 factors. So There are 5 factors, and I'll go into a bit of detail as to what each of those are, but just make note that the amount of time we're going to spend on each of those 5 is vastly different. I'm going to spend about 7 minutes talking about the first one, which is jurisdiction, and 7 weeks talking about grounds. And like anything in law, to be honest, once you start to get into it, you never know how far down that rabbit hole you can go. Judges do like to talk about administrative law quite a lot in decisions. Unfortunately, there's a lot of case law. It's quite long. And to be perfectly honest, this is an area of law where you'll get a good handle of the cases and the decisions, particularly that will be done in the Australian High Court. Sometimes when you're reading these, especially things that are decisions, 4-3 splits, you think, well, this really could have gone the other way. So that may come up quite a lot in the subject. Some things that are a little bit not particularly clear-cut, and particularly things from the last 10 years or so that we'll go over. Some of these things are, if these issues do arise in practice, there's going to be some real serious scope to make arguments either way. So just make note of that. So we'll start by talking about jurisdiction, where things sit at the state and Commonwealth levels. To be honest, that's not a big part of this subject. What is much, much larger is this concept of justiciability. I pronounce that word particularly poorly. I don't know whether it's my accent. I don't know. It's justice. Oh, yeah, that word. We'll talk about that for, it'll be probably the bulk of this lecture, and then look at how that sits in the context of certain decisions under the statutes. All right, now, there is one thing that I will note. This distinction between judicial review and merits review. It's a huge, huge, huge distinction from the purposes of us doing this subject. As law students, most of whom, 95% of you, will go on to obtain practicing certificates and actually be out there in the world going and doing things. And for most of you, you are going to find that if you're involved in this area of law, the area that you have the most scope to make changes and do things and impact, change the world, is in the area of judicial review. The reason for that is that judicial review is about, I guess, how well a particular decision maker has adhered to rules and principles, the actual laws that are there. And this is a really, really important distinction. I'll probably harp on about it and wave my arms for a few more weeks about it. But fundamentally, judicial review is about determining whether a decision has been made according to the law. Whereas merits review, that we'll come back to in about week 9 or 10, is looking fundamentally at the substance of the decision itself. That's a really important distinction to make at this place. And if you guys can literally just do a thumbs up and go, yep, got it, move on to the next point, that would be awesome. Because that particular point, it's the first of many sort of sticking points that students and practitioners have had with this particular area. Yep. Can you elaborate on substance? Substance is the actual factors that a person is taking into account. So an example might be the having or taking an issue of, this is one a bit close to home, a child support services tribunal hearing. Merits review is about putting themselves in the shoes of the original decision maker, weighing up all of the different factors, taking into account that this person has a very high income and this person has a very low income and this person has adhered and followed the rules and that person hasn't followed the rules, weighing all of these things up and coming to a decision. It's looking at the substance. That's what merits review is all about. And that is something which is best done in tribunals. And you will notice for the next 7 or 8 weeks, we won't talk much about tribunals. We're going to be talking about courts, because we're going to be looking at judicial review. It's not that we don't care. It's not that the judges don't care about what the actual result and the weighing up of evidence is, but for the purpose and scope of judicial review, it's about the process of coming to that final result, not the result itself. Similar, if you think of it, this distinction almost between fact and of law. What's the fundamental difference, law students, between issues of fact or findings of fact and findings of law? Findings of fact, you can't appeal. You can't appeal findings of fact. And that's why, in many ways, it's analogous to the system where you have finders of fact, be they juries or judges wearing their fact-finding hat, and appealing things on issues of law. Here we care about the law and how the decision's been made, whether they've jumped through the appropriate hoops. Okay, now, a little bit tongue-in-cheek, I was trying to think of a good mnemonic for aspects. I don't like using the word element. Oh, I have used the word element in the slide. Shouldn't really say element, because element has a very particular technical meaning. Really, they're necessary conditions in order to start going through, looking at a decision, and using the courts to seek some sort of result. So, again, jurisdiction, we're going to talk about for about 10 minutes, and then the rest of this lecture will be devoted to justiciability. I'll get there one day. So, 5 factors. Standing, we're going to spend, I believe it's 1 full lecture, which I believe is next week, and we'll be talking about that for a decent period of time. And then grounds is a lot, I think 4 weeks that we'll talk about, and then 1 for remedies. And the key thing to note here is that in order to challenge a decision of the executive arm of government through the court system, these 5 things have to exist, and they're expressed in different ways in the common law and in the statute. The court has to have jurisdiction over that particular issue. The matter itself has to be justiciable. In other words, something that's capable of being resolved in the courts and court system. The particular person bringing the action has to have standing, the ability at law to bring that particular action, which again varies between the common law and the statute. You have to have a ground. You have to actually have, I guess, fundamentally a reason for bringing the action itself. And there has to actually be some capacity for it to be resolved by the courts. You guys mostly would have done equity with Tina just recently. Remember that maximum of equity that goes something like, equity won't do things that are futile. And in that aspect, judicial review is quite similar in that if you meet those first 4, but it's absolutely pointless bringing it to the court because all of the parties are now dead, for example, or the substance of the matter is now meaningless in terms of the result. Then the court, you won't be able to go to the court to bring that. Okay, let's do this. Right. Now, first of these, jurisdiction. You guys remember doing LA3006? Most of you with Van, might have been with Mel, maybe some of you, I'm not sure. And it would have talked about jurisdiction. Remember when you're trying to determine which act's interpretation act in order to apply? Remember that? Nicola's like 10-step model. This part, is, at least in that subject, was quite easy. You just look, is it a Queensland statute? Use the Queensland AIA. Is it the Commonwealth one? Use the Commonwealth one. That's pretty easy for this. In admin law, it's a little bit more complex. And the reason for this extra bit of complexity comes down to how really judicial power exists in our legal system. And one of the reasons why I don't want to go too much in depth with this is that Salome will go over, for you guys that are doing constitutional now, some of these cases with what's called the cross-vesting legislation. If you were doing this subject in the 90s, you'd be spending a lot longer talking about jurisdiction. But a lot of these things have been solved largely by the states in around about the turn of the century, just giving off a little bit of power, referring matters to the Commonwealth. In brief, there was a case, I think I mentioned it last week actually, Mr. Cable, where the New South Wales Parliament decided to pass a piece of legislation to keep one person in custody and one person only, and they named that person. And a whole series of cases ensued, and the result was pretty disastrous in terms of what they call the cross-vesting rules, the ability of the federal court to hear state matters and state courts to hear federal matters. Again, largely these things were solved by referring the powers, but the net result of this was, the real, I guess, principle we took from all of those things is that federal courts must exclusively have and be federal courts. So the federal court itself is created under Chapter 3 of the Constitution. Part of that, part of the stringent separation of powers that the High Court elaborated on in a series of cases in the 90s, said that, look, that means that while state courts can do federal things, federal courts, other than the High Court, which can do anything, can't do state matters. That was really where that came about. Anyway, I heard of a guy called Mr. Alan Bond. I don't know whether it's a thing for most of your generation. Alan Bond was something of a larrikin. Went to the High Court lots of times in the 90s, and very unfortunately, he had very good lawyers that would win a lot of these things and get whatever particular result. And so a whole bunch of constitutional rules have been changed as a result of that guy's inability to accept adverse results to himself. Okay, last week we looked very, very, very briefly at the statute. And you guys remember when doing contract with Rachel? All those halcyon days so long ago. And contract law, remember, is fundamentally grounded in common law. And you've got a few statutes that sit over the top. Sale of Goods Act, for those who would have done commercial law, you would have the Australian Consumer Law. These things sit over the top, but fundamentally you learn the common law rules first. For admin law, it's actually a little bit easier to start with the statute, where they've gone and really codified all of those rules. A bit like, actually, funnily enough, the Sale of Goods Act. You don't really, Tom doesn't really go into what the common law was in 1896 or whenever those things were codified. I'm not really concerned about that. Once it's in the statute, that's really the easy way to go about doing it. And partially that's because we still are going to look at the common law rules, but they're a little bit more complex and archaic, unfortunately. So the starting point here is that the federal parliament has given the federal court, and it's in the section 39 of capital B of the Judiciary Act, and the High Court, and all of the other courts in the federal system, it's called the Federal Circuit Court, I think it's called these days, the ability to hear these matters. There's just a few sections that says, yes, a person can bring an action. However, in section 75 of your constitution, it also gives a person the power to bring an action against an officer of the Commonwealth in the High Court. So there is, and that can't be, it's a constitutional thing, that can't be excluded. by statute. Parliament cannot pass a law to abridge Section 75 sub 5. They can't. It's in the Constitution. You have to have a referendum to change that. And so, again, we'll talk about the common law right to go to the High Court under Section 75 a bit later on. And finally, there's the Queensland equivalents there as well. These are the mechanisms that a person who wants to bring an action to review to the courts. And that's it. Told you it was only going to take 10 minutes. In terms of this subject, that's pretty much all you need to know. However, a bit like going back to 1102, when you are doing this in a structured exam environment, and particularly when you're producing, usually for most of you, we'll produce practice exams and sort of model answers through going through previous year exam questions, you do need to mention these things briefly at the top. Hey, the federal court has jurisdiction to hear this particular matter under this particular section, and here is the place where you get that rule from. It doesn't have to be very long. Is there any questions on that? That's the first of 5 grounds. Took 10 minutes. Right. The next one, which will be the remaining length of time for today. Judicial, yeah. That word there. Can this particular matter actually be picked up by a court and examined? Okay. Now, clearly there are going to be some things which the court just doesn't have jurisdiction over. We're going to go through some of those. Some of them are mapped out in the statute. But fundamentally, this test is a test that you have to apply, and there's a series of rules and sub-rules and sub-sub-rules that are going to apply in certain situations. But fundamentally, this is the question that we're trying to answer when we're determining whether or not a matter is justiciable. And this line, which I've paraphrased slightly, but this line is going to be stuck in your head forever and a day. Those that go off and practice will hearken back to those glorious days in your carefree youths, thinking back about the guy waving his arms in administrative law. Because fundamentally, the statute and, in fact, the judicial review broadly is about seeking review of decisions of an administrative character made under an enactment. Now that phrase, you can write it down, you can download the slides, you can do whatever. It's probably just easy to stick that in your head right now. Because really, fundamentally, that's what this is about. And they've just explained it in a sentence. Look, as we go through and we look at the ADJR, it's a bit more to it than that, but for the purpose of looking at just this area, justiciability, decision of an administrative character made under an enactment. What does that mean? It means a decision's been made by a person or an agency or a body under a governing statute. Some examples, the commissioner has made a determination that you need to pay $10,000 more tax because you did your return wrong. Or you've been declined a passport for grounds of national security. Or you've been declined an application to seek asylum. These things are all administrative decisions. And again, for those that have had to deal with Centrelink, being declined a particular entitlement for a series of reasons. That's a decision that's been made under an enactment. It has administrative character. I'll explain what that is a little bit later. And what's the enactment? The social securities legislation, the series of them. Really, that's what that part's about. Any questions on that so far? Because this line will be coming back to again and again and again. It'll get really boring. I did warn you guys last week that a lot of the stuff is sort of going to repeat itself, sort of building layers upon layers upon layers. There's 5 aspects to judicial review. This is the second one, and this is really the starting point, the linchpin that we're going to use to analyse each of those things. Now, this might be tricky to see. Hoping it's not. I can't see it very well. I'm going to wait for that to come up. This is section 3, the definitions section of the ADJR. It should have at the top somewhere. And again, I've paraphrased it somewhat, but it'll still be in there. It's an administrative decision, decision of an administrative character made under an enactment. Just make note that this is the section that you'll be using, and you'll notice there's a few more things in it than just that. We will have to go through it and examine those. For example, one of them, a decision made or proposed to be made or required to be made. So decisions are simply broader than what we would have from our natural, ordinary English definition of that word. And just make note here, just about halfway down, it's clearly expressed in this part, a rule that it probably didn't even need to express. One of them is that decisions of the Governor-General, you can't review. You cannot review decisions of the Governor-General or things that are in Schedule 1. I've got Schedule 1. I do not have Schedule 1 here. What sort of decisions, just we step back and put ourselves in the system of, we're just sitting here determining what a good system of governance for our society would be. What types of decisions would the Federal Parliament want to put in a list of things that can't be reviewed? What's some examples? What are some things that you don't want? Sorry? Yes. Yep, absolutely. Areas of criminal law. Yep. Particularly the substantive areas of criminal law. Other areas, though, are the things that if everybody was allowed to go and review, they probably would. Tax. It would be great if you could seek judicial review on every single thing to do with every time you were taxed. That would grind our system to a halt. Issues of national security, things like ASIO, they aren't subject to these things. There's actually a host of others, though, things that are a little bit less intuitive. Certain industrial awards, like Coal Act, things under the Coal Act, I don't even know what that's all about. Coal, probably. But it's the types of area, and for those that have got laptops, you can go and have a quick squiz at this. It's Schedule 1 of the ADJR. It lists across several pages a series of bits of legislation, either in entire acts, some of the military acts as well. You can't seek judicial review of a lot of things that occur in the military. They have their own systems. Some things in migration, not everything in the Migration Act, but some very specific things. Parliament has said, no, that is not going to be subject to the ADJR. It's not to say you can't give it a go. We'll talk about that a little bit later. All right. Now, a little bit further down, this is in section 3 of the ADJR, where it's got a collection of definitions as a schedule, but there's one a little bit further down where they talk about this definition to decision making in a little bit more depth and give some examples. Hey, decision making includes a bunch of these things. And I think it's helpful to just have a little look down that list. Again, try to associate these things and relate them back to yourself. Times where you've gone to apply for licenses, or having, as an example, applying for consent to do things. Something may come up a little bit later for you guys if you're involved in property, real property, and trying to go and do things and having it knocked back by statutory bodies. Council. These things happen, and knowing that this is an avenue to make people do their job properly. And really, I think that's a good way of thinking of it. Judicial views about making people do their job properly for those that are in the civil service. Now, the Queensland equivalent, a lot of the time, these things are in alignment. Sometimes they read a little bit differently. For the purposes of this particular lecture, there's no real substantial difference, at least I'm not going to elaborate on any differences between them, but just note they're phrased a little bit differently. But it'll still have the same words in there somewhere. Decision, administrative character made under an enactment. And they're phrased something a little bit. And all right. Now, okay, so that's broadly, that's what justiciability is about. Now, as you could imagine, people have argued about this for quite some time, both before we had the statutes. 1977, I believe, 76, 77 was about the time where the AAT came into existence, and about the same time that this, the federal statute came into effect as well. And so most of the case law that we look at is from that point forward to today. And there's a little bit of chronology. So this should be the point now where things are a little bit more familiar to us as law students. I'm going to talk about some cases. And you can take notes if you want. Like I said, I've put a copy of these. And the reason why I like, me personally, I like phrasing particular principles, or my take on a particular principle with a citation. The reason for that is, I don't know, I think like a robot. In fact, I had, a few years ago, was doing some just volunteer legal work with QPIL, which is now Law Right, which is no longer in Townsville. And one former student over here had a look over something that I drafted. And he said, "Simon, I don't want to sound insulting or anything, but you write like an academic." I'm not too sure whether that was a compliment or an insult. I haven't really worked it out. But you'll find that when you get material from me, it does come across as a little bit robotic. I like to have things, that IRAC-style way of doing things. You know, identify the issue by writing it out as a heading with a question mark, underlining it, stating the appropriate rule or principle, completely agnostic to anything to do with the facts, then applying that principle without introducing any new ones. And I repeat that process. And if I ever feel the urge to break that, I'll usually break the question down into multiple areas. What I found, though, is as a result, these things come across as propositions. But make note, when you guys are reading the material for this subject and reading decisions, how you might phrase that same principle could well be different to how I'm going to phrase it. So just make note. These things are very much the product of one's own brain. And that's why I recommend, particularly, you know, we don't have a huge essay for this subject. So you really got to think about stuff like this for your exam. Way, way, way off in the distant future. And your future self is probably there in 4 months from now, cursing your current self and saying, pay attention to this, get started on your exam prep now, make life easier. I like writing things out like this. It's up to you guys how you want to go about preparing for your own exam, both for this subject and for others. All right, so what is a decision? And really, the fundamental thing here is that the decision thing is a decision at common law, which falls under the statute, once you've fundamentally and finally changed something. All right, and this has gone backwards and forwards between the courts. They bounce things around, make a few changes and go, oh no, that went too far. So starting with Reardon Parole Board, there you had a person who was denied parole for whatever reason. Now that's a decision, right? They've made a decision to not give the guy parole, we would maybe ordinarily think that as being a decision. But what the court said there is that, look, when you're going and making preliminary steps or stages, you're going and investigating things, right? Getting a little bit of information, all right, that in itself isn't going to be a decision unless it's going to actually change something. You're actually going to impact somebody's rights and have some substantive effect. Because a few years later, in Lamb and Moss, which I believe was also a parole decision as well, they sort of, again, went from this sort of narrow thing for a few years period and widened it somewhat and said, look, well, we can call each of these investigative stages decisions. They could be. But still, fundamentally though, it really is about this operative effect. Now, Chief Justice Mason, this is one of Alan Bond's cases. Yay, go Bondy. He, again, was in the majority here, but I believe his judgment was just his own. So just him writing. And this is a pretty definitive, these aren't his exact words, so please feel free to actually go to volume 170 of the Commonwealth Law Reports, starting at page 321. And on page 337, you can read Chief Justice Mason elaborating this some more, and really, when trying to explain or express what a decision is, it has to be substantive, not procedural. Does this sound familiar? Does it sound familiar to anybody, again, who might have done LA102? Do you remember anything like this? I don't think I taught any of you guys 102 a long time ago. Well, anyway, there is the principle to do with retrospectivity. Does this ring a bell? This distinction between procedural and substantive. Substantive things change the world. They materially alter people's positions. They impact rights, either giving them or taking them away. Procedural things we can characterize as being steps that lead towards the substantive change. And really that's what they're talking about here. This procedural stuff, fundamentally, isn't really justiciable. It's the final, there's a clear, determinative, and final result. That is the part that can fall under the ambit of justiciability, and thus is the decision for the purpose of judicial review. Is this clear as mud? A lot of this stuff, again, I'm going to try to rephrase it. I know some of the other stuff, Luke apparently is very, very good at doing this, and saying, oh, maybe I could explain that in a different way. So we've got to make a decision. We've got to go and a person's challenging their tax assessment that the commissioner's made. All right? As part of making this decision, all right, the ATO staff, they're going to go about looking at the person's records. They're going to go about grabbing information, checking things out, and checking the appropriate rules and principles that both the commissioner as well as the statute got in there. Then they're going to make a determination at the end. And fundamentally, this procedural stuff, by default, is not going to be justiciable because it doesn't have this final effect. Now, again, we think of an analogy. If you start to push a rock, you're about to push it off a cliff, there's a certain point where you're pushing the rock and it's got this inevitable consequence. We've gone through, done all of these steps, and we've gone so far into this process that the result is going to be a fait accompli. Then at that point it can be considered a decision. And it has to reach this point where it has this aspect of finality. The rights are going to change. Okay. Does anybody use the chat on this? Do you think? I thought it was a good idea, and I thought people that wouldn't be coming to class would be like into it and asking questions and stuff. But I think in practice, most of you guys come to class because the tute's straight afterwards. That's like, oh yeah, I put two and two together about that. Okay. Now, let's go through a few cases, starting with Harris and Brice. Brice is the Sex Discrimination Commissioner, and Harris, I believe, is the minister that was in charge of, it was in the Northern Territory. And there was a stat body, and the stat body had to go and administer Indigenous groups, or deal with, or work with Indigenous elders. And there was a lady, Miss Valance, who basically didn't get a job. And her belief was, the reason she didn't get the job was because certain Indigenous elders didn't want to work with women. What year is that? Early 90s. Now, they did go about investigating this. And this is the difficulty with things like employment. Who here has ever been turned down from a job? Who was grumpy about that fact? Who, now armed with this information that there's this thing called judicial review, is starting to do this, right? Well, my next job interview, it's going to be great. The trouble is, when going and doing this investigation, choosing to go and investigate something or not, and making this process of deciding to investigate isn't usually a decision itself. Why? Because it doesn't have this aspect of judiciability. This going as part of the procedural aspect, you can go and investigate particular things. And that's what stat bodies do. Again, if we go back, this is the Sex Discrimination Commissioner. They will have their own internal policies, documents, things that they'll take into account when determining whether they're going to go and investigate things any further. And that decision by itself is not usually reviewable. Okay. Similarly, referrals. So, Mr. Edelson, this is actually Jeffrey Edelson. It's kind of, be careful what I say, a notorious personality in Australia. He had a string of, he's a very old man, he's probably about late 70s now. He had a string of, 25-year-old wives. Does this guy ring a bell over the last 10 years or so? Anyway, he was he got investigated for doing something naughty. And part of this process in the medical fraternity was that there were a couple of different bodies responsible for things. And one thing and again, I think it was to do with insurance, so that when you're no longer a practitioner, you've got difficulties doing things with insurance or if you're under investigation. So there were a couple of different bodies that would go and investigate these things. For example, as an analogy, as law students, if you do something bad, what's the process for doing that? Well, usually there'll be an internal review of your conduct or an investigation, and then things will get referred elsewhere, the university. And really what the federal court said in Edelson's case is that mechanical procedural process of referring it to another body, which is usually the done thing for these, is not usually a decision in itself. Going and referring something to the proper body who would actually go and do the investigation isn't usually subject to review. But if this process of doing this preliminary investigation actually really does substantially impact your rights, then it can be a decision. And Salerno was the result of a raid. They actually decided as part of their investigation, we're going to go raid the guy's house, and they did. So if federal police rock up to your house, bash your door in, grab all of your computers and documents, that actually has an impact on you. And for the little bit cheeky, really, for them to turn around and try and argue, well, actually, that's non-justiciable because we're just doing it as a process of investigation. No, that actually impacted the guy's rights. It had a real substantive effect. Okay, the Commonwealth and the Human Rights and Equal Opportunity Commission is factually quite complex. It goes something like this. There was, I think it involved elderly men with osteoporosis. What's the difficulty with osteoporosis? Most of the time, it impacts women. So it's the weakening of the bones, I think, through calcium deficiency. Again, people that have done more than Year 10 biology can probably fill in the gaps better than me. And as part of this, though, is that there was a scheme where they would have some form of subsidies. The trouble was, again, for policy reasons, it was they determined quite early on in this process that, look, this really only impacts women, so we're just going to make it that only women can apply for this. Again, it's for a policy reason. And what they had jumped up and down, this group of men who suffered from this condition, not very many, but they'd suffered from it, is, look, there was some contrasting evidence here. And as part of this process of investigation and coming to this particular result, ignoring that piece of evidence at an early stage of this investigation could be deemed justiciable, could be deemed to be a decision, and thus capable of review. You choosing to ignore this evidence early on, even though you've got a very long procedural process of coming to the final determinative decision later, this can be a decision in itself and subject or capable of review. Okay, in Resort Management Services and Noosa Shire Council, that's a series of steps. Now, again, procedural things, not subject to review. Substantive things are. However, this is one of those things where you can make an argument either way. Why? Because you can have a series of steps, like pushing the rock off the cliff, where there is a point in time where you are actually doing something substantive. You are actually going to, or have done, materially altered somebody's rights. In that particular case, it was a series that the particular stat body was, Noosa Shire Council. They had their own internal policy when reviewing applications, and it had like 8 steps. 1, 2, 3, 4, 5, 6, 7, 8. And what these resort management services were able to argue in that case, well, I think they lost on other grounds, but was that when starting down this process, there can be a point where you have actually made a determination of sorts. Even though, in theory, each of these things is procedural, there might be a certain point where you've started to push this rock and it's starting to move on its own. And they said in that situation, once you've reached the 3rd step of doing this, you are actually going to substantively change or alter their rights. And as a result, that is going to be subject or capable of review. Okay, the final one there, Pegasus Leasing. This is a tax case. It's to do with a statement that's been made. So a stat body can go put things on their website, right? These aren't legislative instruments, just statements of opinion. Those statements fundamentally aren't decisions themselves. What they do with those decisions and how they go about using them, well, that can be a decision. But usually putting up these statements of opinion is usually not. I actually had something like this come up in practice, of all things. It's hilarious when you have me starting to talk about legal practice. To do with the Housing Commission in Queensland having a 3 strikes policy. All right, and so basically we had, again, this was with Laura, had a client who had had 3 strikes. You guys are aware what that means, sort of conceptually. You're a terrible Housing Commission tenant, and you've had 3 substantial complaints. And on the 3rd one, when you're kicked out, you can't apply for state houses or whatever the particular rule was. It's something adverse anyhow. And what the department were arguing is that, well, they've had their third strike. We're bound to not give these people this, or let them apply or reapply for community housing. And when I was reading this, we stepped back and went, whoa, no. This is a policy. This is just something that you guys have just made up. When you are saying you are bound by it, you're really being a little bit dishonest. You're certainly not bound by it. In fact, you can't choose to bind yourself because this policy wasn't passed by the Queensland Legislature or legislation that would let the minister delegate particular rules and structures. It wasn't. It was an internal government policy. And that itself, in publishing that, that's not going to bind you in any way, shape or form. Making these particular statements and plopping them up on their website, I mean, that's just that particular department saying, well, this is something we might do. Choosing to then go and use that to make the decision-making process, that can be a decision. But actually putting the statement up on the website, it's not a decision in itself. It's not justiciable. Clear as mud. All right, I think we might just take a break, largely because my voice is sore. I actually don't think I have too much more material either, so we will take a break, if that's all right, guys, for 10 minutes. And come back at about 2 or 3 past, because there's not really a lot of point finishing early, because we've got the chiefs right after. All right, I'll switch this over. I've just had a look. Turns out there's only 3 slides left. Boo. Boo. That wasn't well planned. Okay. So we're still looking at the this ambit of justiciability. A thing as a necessary component or requirement in order to seek judicial review of a decision. And so the last 3 or 4 slides are about whether or not something is or isn't, maybe or maybe not, a decision in itself. All right, remember, decision made under enactment of an administrative character. And so this next part is looking to try and determine whether or not a particular decision actually falls under the area of administrative law. Usually this is in contrast with judicial decisions and legislative ones. Okay. And the other, I guess, aspect when we're determining whether something is of an administrative character or not is whether or not it's been done by either one of the bodies listed in the statute, ASIO and certain parts of the Migration Act and the Tax Commissioner and so on, or the Governor General. And in those situations, then it's not going to have this fundamental administrative character. The other really key aspect or area that you can't use judicial review for because it's fundamentally not of an administrative character are political decisions. So decisions that are made by cabinet and not subject to review by the courts. You can't go to the courts and change, alter, or make them do this in any other way. That kind of makes sense. The whole point of having representative government is that we elect people, Parliament, and they choose amongst themselves the executive, and the decisions that the executive make and the cabinet make, well, they're going to be one and the same, behind closed doors, usually on party lines. And those decisions kind of have actually been endorsed by us as the voter at the start anyway. If we don't like it, vote them out. Wait 3 years. And so this, though, actually extends a little bit further than decisions that are done or made by cabinet. In this first case, this Reed Ditford, that involved, I believe, a guy who was in Germany who had been arrested. And charged, might have been convicted, I'm not sure. Nonetheless, the Australian government had to jump in and cut some sort of deal with the West German government in order to try and get this guy extradited. And what they, again, as part of this process, certain terms and conditions were imposed on this as part of this arrangement. And this guy didn't like that. He thought he wasn't consulted as part of this arrangement that had happened between the two governments. And he was quite grumpy about it. But the court said, well, you can be as grumpy as you like. That decision that's been made to extradite you from West Germany is fundamentally a political one. That has been done by the executive, but it's been done under essentially the external affairs power. They are doing what inherently is their job to go through and do these things, and they've done it on political grounds. As a result, this falls outside what the courts are going to want to go and investigate and look at. Now, O'Shea was, I guess it was kind of similar. O'Shea was, it done some pretty awful things. I think you find about things in the administrative law sphere is that the High Court generally takes into account public sentiment and feelings. They won't tell you that they do, but they kind of do. Because this guy O'Shea, he lost. He lost this because the High Court said that in this particular case, and I think it was to do with granting of parole as well, but he was a child molester. And really interesting when reading these sort of decisions, and in fact you see it now in the High Court decisions too, where you go and reading and thinking, oh, they're, I mean, we're not quite at the same stage that the Americans are at. I saw this number the other day. Since the year 2000, the US Supreme Court has essentially decided things on political grounds, so along party lines, 98% of the time, which is horrifying. I mean, nonetheless, O'Shea lost. And they said there that, look, the decision, in this case of the South Australian government to do or to not do these things, that's outside the scope of us to look at. It's not something that we are going to do. Now, that's not to say that all political decisions are fundamentally excluded from this review process. And this case, there's a few of these Pico-Wellson cases. This is the 87 one. And the difficulty with Pico-Wellson, though, and again, they did find in that particular case they don't want to get involved. But they did say that, look, we're not saying that we don't get involved. The High Court can't or is expressly removed from reviewing decisions. But in some situations, it's inappropriate for us to do it. And those situations are ones where the facts and the various bits of policy that are involved in it are really complicated. One of the things, again, you guys in your foundational legal studies, you must remember this, that in our system, judges don't get off their seats. They don't go and investigate things themselves. Fundamental tenet of our system, in our adversarial system, is that the judge sits there and she or he is presented with evidence. All right, the jury and the judge do not get up and investigate. Now, this is not the case in all legal systems. In the inquisitorial system, I guess the equivalent, I think they call them magistrates, they accompany the police. They go around with the police as part of the investigation, gathering evidence and doing things. They're part of this process. That is not how our system works. One of the, I guess, downsides, I suppose it's a downside, is as a result, the courts are very, very bad at trying to deal with and resolve complex issues. They don't have the ability to just get up and ask for more information here or there. Again, one of my research areas is in Section 92 of the Australian Constitution, and Sir Anthony Mason made this comment when they were having a couple of cases in the early 90s. Look, we, the High Court, would be really happy to see your data. We would actually like to go and have a look at the data and see how and where this particular policy, and again in that case it was Castlemaine-Tui's. Has everybody done constitutional law last year? A couple of years ago? Do you remember that case? Castlemaine-Tui's, again owned by Alan Bond, to do with the South Australian recycling system. The rest of you, oh, you've got a real treat when you do Section 92. That was the worst sarcasm I could muster. But as part of doing this, though, is that neither side wanted to give them the data. Both sides thought, we're probably better off not supplying the High Court with all of the economic analysis, even though they asked for it. Bench asked for it, please, can you give us the data? We want to go and determine whether or not these things, and in this situation it was a proportionality test, whether it was reasonable to, the particular law was reasonably well adapted to this particular circumstance. Oh, hey, we need more data. Sorry, Your Honour, we're just not going to supply that. And the court can't do anything about it. And so as a result, the courts have said that, look, it's not that we can't go and examine. It's not fundamentally restrictive on us. It's just that we're not the best place for this. And the more complex things get, and the more interrelated policy arguments and things that have to be taken into account, unfortunately, the executive is actually the best place to do this because they've got the resources. They have all of the bodies that can go about and investigate these things. They can go into the world and find more information, whereas we can't. And really, that's what they're trying to say in that particular Pecos case. It comes up a few times. Finally, acts of state. I remember a case you would have done with LA3001 a couple of years around the room at me. Co and the Commonwealth. Does it ring a bell? Does it ring a bell to anyone in the room? Anybody remember Co? Mr. Co, Paul Co, he rocked up to the High Court and was trying to argue that the court and the systems, the land had not been taken under whatever the Westphalian model. Therefore, all of the systems of government that had been purported to exist since 1788 are in fact invalid. And some of the judges of the High Court, good old Gibbs, were quite happily to just ignore this and strike it out. But some of them were willing to at least engage the material. So again, Justice Mason at the time, he was willing to engage, but he said, look, when you're bringing an action to a court and you're trying to argue that the court has no power, it's invalid in some way, all right, well, two things are wrong here. Firstly, that's an act of state. It's something only nation states can go and do to declare these things. And secondly, it's a circular argument. We don't have the power to declare ourselves invalid, because if we did, then we could, then we wouldn't, then we can't. See what I mean? We don't have the power to declare ourselves invalid, because if we did, then we couldn't. Anyway, that was what Co was about, at least as far as what Justice Mason had said. Now, here in Thorpe, something kind of similar. Thorpe made a request, and again, it went to the High Court and was considered by just one judge. Guess which? It was Michael Kirby. And he was extremely sympathetic to the applicant in this case, because the applicant wanted to force a decision to be made, in other words, force the executive to go to the United Nations and request that an investigation be made about the genocide of Indigenous Australians. Okay. And, Justice Kirby is very sympathetic here. He's just saying, look, while, there may or may not be genocide, I can't determine that here. And going to the United Nations is an act of state. All right? That is fundamentally and inherently a political decision. It is outside the scope and completely inappropriate for the courts to really be interfering with that at all. There may be genocide, in which case, well, Australia has signed up to all these conventions, and as part of signing up to these things, and is you then go and ratify them by enshrining them in domestic law. So if there has been genocide, it's within the system that you have to bring this. So therefore, we can't allow you to bring this action under judicial review. There are probably some other areas to examine these things under. Really, that's what that was about. Acts of state, non-justiciable. I don't have this requisite administrative character. Does that kind of make sense? Because I'm hoping for most of you guys, you're drawing upon knowledge that you might have gotten first year. First year is probably a little bit hazy for some of you. That's all right. So just a lot of the stuff I'll be hammering into you over the next few months. Okay. Flip. Flip. All right. Some more things to note about what administrative character means. And really, the best way of thinking of it is in contrast to the other powers. So we think of what legislative power is and what administrative power is. And they can sometimes blur a little bit. Delegated legislation. That's where you give someone other than Parliament the ability or the power to make law, to make legislative instruments. And that can be a little bit problematic. Has anybody ever gone through and tried to fight a parking ticket or a speeding fine? Anyone? No one's ever tried to contest any of these things. Ah, you're in for a real treat. Go through the transport and other road users, it's called TORUM, I can't remember the exact acronym. Have a go through that. And you'll find, as you're going through that a lot of the offences that are in there have huge penalties. You can pay like $3,000 for a parking fine. And you sort of go and you read it and go, oh, wow. Then you go to the council website and you realise that while, yes, you can have this much, this is the maximum, when the council goes and makes their delegated legislation, they can go up to that, but they can't go over it. That makes sense? The specific areas that have been delegated usually have a cap, usually a higher one, and the lower ones can't go beyond that. Going beyond that is a term that we'll come back to many times throughout this semester, which is ultra varies, outside the scope of power. But one thing that they can do is to both create this delegated legislation within the scope of the larger act and replace it afterwards. Commonwealth and Grunsiet. Have a look at the year and then have a look at the surname. You could probably put two and two together. Grunsiet was a person who was imprisoned during the Second World War. And as part of that, the High Court, look at that time, to be honest, pretty no nonsense. 1943, things are going to come up and you're going to have a really hard time trying to seek judicial review. And in that situation, they said that, look, what's been done is a particular power has been delegated by the minister and they have the ability to make bylaws or rules or regulations. And fundamentally, that is a legislative function. No, it's been done not by the legislature itself. And Chief Justice Latham sort of mapped this out and talked about it, that look, legislative power is about mapping out what our rights and responsibilities are, mapping those out in statute or delegated legislation in instruments. Once those are mapped out, it's administrative power that then goes and reads them and applies them. Goes into the world, follows that stuff and does it. Even though it may be the same body that then goes and changes what the delegated legislation is, all right, that is going to be a legislative task because it's made under delegation. Okay, and that leads on to the next two. Both of these involved this process of delegated legislation. So Blewett's case was a schedule. The minister, and it was to do with, I believe, kickbacks that the medical practitioners would get. I think it's Queens. Yeah, it is Queensland, yeah. And the minister just decided to change it. We're going to just replace the schedule with all of these rates with a new one. And so the argument there is that, well, is that a discretionary call? And it's like, well, no, it's actually a legislative one. You're going, mapping, you were allowed and been given the power to create delegated legislation, and that's what you're doing. You're allowed to create it, you're allowed to change it, provided you follow all of those structures. And fundamentally, the content of that that's been decided, that's legislative in nature. You can't review it. And again, it's something that when we were all studying first year, thinking about the roles of particularly the council. Has anybody had to work with council or had to deal with them? Has had to deal with council at some stage? Oh, there you go, a couple of them back. Remember that all of the councils are creatures of statute. They are statutory bodies. They have a head. We call her Jenny, and they have their council and they have their own systems of governance. All right, but it's not really just Commonwealth, state, local councils. That's fundamentally not. It's a flawed way of looking at our system of government. All of the councils are just creatures of statute. They are inherently responsive to the statute that created them, so the Local Government Act, and all of those rules that have done and the powers they have to delegate fall under that. So we think about it. When you're dealing with the council, all of their decisions are good, pretty much all of them are going to be judiciable, not validly passed bylaws. So if you go, and again, look, has to be validly passed. I went through to check, make sure they had actually published them by the date that they were supposed to do and put them in the appropriate places, and damn it, they had. That's this distinction between the legislative and the executive. That's the distinction there. So, and that is the sort of thing, it's like a bread and butter type question. That's the sort of thing that may well come up in your test and or exam. That sort of stuff. Okay. If you don't like the decision of what a judge has done, we'll say in the district court, what can you do about it? If you don't like the decision of Judge Lynham, I think it is these days, JCU grad. If you don't like a decision, what can you do? Yeah, appeal it on issues of law. We don't like it, we're going to go further up. Now, appeals, just in our system of governance, all appeals are creatures of statute. Right? It is going and asking under a statutory framework, asking the higher court to usually review, check, or throw out the earlier or the lower decision. That's the first thing you need to know. All right. The other important thing to note is that our system of review, this judicial review, is fundamentally different to the appeal system. If you don't like the decision of a court, you can appeal it to another court. If you don't like the decision that a decision maker of the executive arm has done, you seek judicial review of that. Now, you could probably put two and two together. What if you don't like the review decision that you got in the inferior court? What can you do? Appeal that, if you don't like that, because you're in the court system now. Okay, but sometimes it can be tricky to determine whether or not a particular decision maker is actually exercising judicial as opposed to executive powers, and particularly, not so much recently, but it used to come up with tribunals, because tribunals with this quirky mix of administrative and judicial power. You guys are probably aware, like the head of QCAD is going to be a Supreme Court judge, all right? But fundamentally, tribunals are administrative decision makers. And we'll go through the systems and structures of those in, I think, week 11. All right, and the key part, or the key point of distinction here, judicial power retrospectively tells the world what the rights of the parties were or are now. And that's that key part. That you're essentially, the dispute happened way back in time. The court is tasked with determining what the rights of people are now. Usually what they were back then, but we can't build time machines. All right, that is what courts are about. Whereas administrative power is about taking both decisions of the courts and the rules that you've got, discretionary powers you're given under statute, and materially working with those to alter the positions of other people. Executive power does that. It changes the rights of parties. It's that substantive aspect to it. Now, our registrar. Oh yeah. Has anyone had to deal with the registrar at the courthouse? The staff that are there, the registry staff. Okay. Oh, for those going into legal practice, you're in for a real treat dealing with the staff at the courthouse. Everything you do and all of the stuff you will learn at law school, when you are there at the counter, it'll be wrong. I just guarantee you will be there, you would have filled this form in, and you put this thing on the wrong page. It's just prepare to be disappointed. The most important piece of advice that I can give you is completely commonsensical. Never say, oh, I'm a lawyer. Oh no, that you're just asking for trouble. Anyway, the registrar has power. They are allowed to do things, again, under the given statutory power to go through and make discretionary decisions, usually to assist the passage of justice. For example, determining whether a matter goes to mediation or goes straight to the tribunal, for example, or to court. Right? Sometimes, under the statute, the registrar will have the power to do that. Another example, registrar has the power to waive fees in some circumstances. And it's a discretionary call. If you go up to, and you ask, bring your taxable income statements or whatever have you, they have, most jurisdictions, the power to go through and at least work with some of these things. They're given some of that power. And make note that even though the registrar is operating in this environment, which is part of the judiciary, and they're often doing things which are bypassing certain processes, going to this court, going to that court, going to mediation, going to these other things, all right? Fundamentally, though, their decisions are administrative and are subject to review, usually. And so, yeah, I think I've already got one more slide. Oh no, two more. What's the time? That is enough for administrative character. Final piece of the puzzle is this guy here. In order to be justiciable, and that second aspect that we need, necessary condition we need for judicial review, the particular decision has to be made under an enactment. And ANU and Burns, Griffith University and Tang both involve enactments. Guess what enactments they were? What's the enactment that lets me be here and gets me paid? It's the James Cook University Act, validly passed by the Queensland Parliament. And each university is created under statute. All right, and I wholeheartedly recommend, by the way, for all of you guys, get to know that piece of legislation, particularly if you do want to carry on and do postgraduate studies in law or elsewhere. Get to know that statute. For example, parking. Who here's got a parking fine from JCU? All right. Has anybody challenged it? How'd you go? No. How'd you guys go? No? Out the back? No? No go. Well, it turns out JCU doesn't have the power to fine you for parking. It doesn't have it. Fundamentally not what it is at all. What it does have is the ability to fine you for not following instructions. So when you go, all of you, next time you're driving into the university campus, you will see a sign. And that sign says, no parking anywhere, except where marked. So the JCU's power, which flows, again, they're making decisions to fine people or not fine people. That flows from the JCU Act, which says, among other things, we give power for the council to pass regulations and bylaws and policies and such like. And one of them is the parking policy, bylaw, whatever it is. And so that's what it is. So every time you drive through, that sign's there. Now, I'm not going to suggest this to anyone on record because that would be a terrible thing. But if you were to go and take down all three of those signs, chaos would ensue. There you go. But it is worth, and I'll heartily recommend, whenever you guys get a fine, or you're being forced to do something from this point forward in your lives, if you've got the time, sometimes it's like, oh, $35, who cares? If you do have the time, try to work out where the source of that power comes from. Go and find the statute. Go and see if they've actually done it properly. And most annoyingly, the JCU guys have done their homework so much better than the council. Council's got loopholes all over, again, not on record. But other bodies that don't do this very often, if you go to Ames, for example, and you get a parking fine, well, do they have the power to do this? Let's find out. All right, now, ANU and Burns and Griffith University and Tang. Burns was a lecturer who got sick, and part of, again, this is going back about 82. All right, these days it wouldn't be very nice to push somebody out because they got sick, but fundamentally, it's said in the guy's contract, if you get sick, we're going to boot you out and just get someone else to teach your classes and not pay you. He got sick, sought review, and the court said, nah. Why? Because the instrument in that case was not an enactment. What was it? What was the instrument? The relevant instrument? No, it's a contract. The contract is fundamentally the instrument by which the rights of the parties is mapped out and determined. Similarly, in Griffith University in Tang, that was a PhD candidate who cheated on her data, just made up a whole bunch of data, and tried to seek review of that. And they said, no, fundamentally the arrangement that you have, contractual arrangement with the university, doesn't fall under an enactment as such. All right, it is not an enactment. It's an instrument, but it's not of a legislative nature. Now, contrast this with Chittick and Ackland. There, they said that, look, yes, there is a contract, but think back to all those things Rachel told us. If you have a contract and one side can just unilaterally change terms of it, how does that work? And that was what these guys said here, is that, look, contracts, once they're enshrined, we've had the meeting of minds between two parties to agree upon a series of terms, promises that we've made, and choose to be legally bound upon. That's cool and that's fine, and that's set. All right? If one side can just choose to change all of their obligations however they like, that's not really a contract. Really, that's going to be a discretionary decision and can be deemed administrative in nature. Well, if one side can just, if you've got the two parties, if they've agreed in that situation to go and make change of terms, you're always allowed to novate terms in contracts. Parties are allowed to come together, mutually agree, either to change or substitute a particular term, or to novate the contract and just have a new one and replace that. But fundamentally, though, if one side can choose to just change all the obligations, the other one's not. It's not really a contract in the sense of being a non-legislative instrument. That's really what that's about. Now, wonderful way for governments to try and get around administrative law is outsourcing. Now, if, let's say I work for the Department of Transport, the roads, who does it? Main roads, I think it is. I think it's the government department. We're doing all the roads. Occasionally they're going to have to make decisions, closing off streets, stopping people to go there and stuff like that. And that impacts people. That changes people's rights. Now, if a delegate of the minister does that, choosing to block off this street and not that street, is that administrative in nature? What do you reckon? Probably is. Seem to have that necessary character of an administrative decision made under enactment, the Transport Act. Things get a little bit problematic, though, when the minister outsources particular roles and functions to somebody else. You guys take care of it. And the courts have had to deal with these things from time to time. This neat domestic training and AWB is the wool board? Wheat board? One of those boards. Either way, it's fundamentally a creature of a it's like a private entity. Things with their own private rules, your own companies, be they public or private, aren't usually subject to judicial review. I mean, that kind of makes sense. The decisions that you're making aren't government decisions. If you were doing it as a private citizen, things get a little bit murky when the minister delegates things and they outsource things, and it gets even murkier in that in other jurisdictions, particularly the UK, they have allowed judicial review on non-private bodies. They have a very broad attitude to this. Whereas in Australia, it's much, much narrower. The High Court had a chance to look about 10, 12, a few years ago, 15 years ago, had a chance to go and map this out. And they kind of politely said thanks, but no thanks, and pretty much left it closed. And so the federal government has a lot of scope to be able to outsource things to private bodies, because those bodies, when doing them, aren't subject to review themselves. That's really where that's at. Okay, got one last slide. One last slide, then we can all... Oh no, we can't go home. There we go, the tube, yay. Okay. Final thing to look at is what they call privative clauses. Privative clause is a validly passed through Parliament clause in a piece of legislation that says this is not subject to judicial review. And if we think about that, parliamentary supremacy, in theory, the clearly expressed will of Parliament is going to trump the other arms of government. In theory, the courts have to follow these. In practice, it is the hallmark of tyranny to put privative clauses inside legislation to stop the decision-making process from being reviewed by the courts. And the courts have bent over backwards to find ways to actually get around this. But nonetheless, there are still validly passed and upheld areas that you can't go to the court to seek review of. That Schedule 1 I mentioned earlier, national security, taxation, certain industrial awards, because let's face it, everyone would want to review the time they didn't get that job. There's a host of these, and a lot of migration things as well. Host of these things. We do have to accept that from time to time the government does actually have to do some nasty things. We don't like it, and we should be jumping up and down about these things. And that, for you guys, and this is now I'm talking to the you of 10 to 15 years from now, when, for a good chunk of you, if you are out there and practicing solicitors, members of the community, and most importantly, also members of the legal community, giving input on things, this is the sort of thing that we should collectively be alarmed and outraged and jump up and down about. Because before we did law school, before we came here, I don't know about you guys, I was always like, oh, Parliament should be supreme, and those unelected judges, they shouldn't have any power at all. Have you noticed that that's changed since you've started to learn a bit more about the law? The more you go through, the more you'll appreciate the position of the courts, and particularly the position of the courts in the administrative function, in terms of reviewing administrative functions. It's a really important thing. Parliament can do it, but the courts, they are going to try really hard to interpret these things as carefully as they can. Okay, and that test, the Hickman Test. So that's Justice Dixon, a long time ago, just after the war. And really the key aspects here is that where there is a bona fide effort to comply with the particular legislative framework by the decision maker, that's in reference to the actual subject of what the legislation's about, and is capable of being referenced by the fundamental power that was given to them under the statute. If the particular privative clause, the privative clause in relation to the administrative decision, will not be reviewed. If these things are true, bona fide exercise of power. And really that's what that part's about. Parliament can still do what it likes, theory, and the courts will follow that. But this test is really the starting point of what the courts use to look at to determine whether or not they can get in and around that privative clause, or whether it is going to be still in operation. Whew, clear as mud, eh? That's the last slide. That's the last slide. We'll finish a little bit early, 10 minutes early. So, what do you guys want to do? Do you want to have questions now, or do we want to spend 10 minutes and then move on to the tute in the other room, which is going to have 85% of the room in it? Does anyone have any questions about this stuff? As we will, again, with a lot of it though, I'll be going over it again. again and again and again and again. I talked to Jamie just before walking over here and recommended that this almost dull repetition of some of the base concepts is going to be really helpful. That's a lot of information. I know there's only like 18 slides or something, but it's quite a lot to sink in. And so I do wholeheartedly recommend that you obviously revisit this material, and I've put the information from these slides, it's online JCU, but also listen to the other podcasts as well. So Jamie's made a bunch of podcasts for this. It's going to be the same material, but expressed in a different way. And this is a subject where you benefit a lot from a different person explaining the same thing to you, because it's going to take a little while for that to sink in most years. Okay, thanks team. I hope that was useful.